Now we will see, we have discussed three topics till now. This is my fourth topic. My first topic was doctrine of all, second one is doctrine of wrath, third one is essentials of tort of defamation. Now we will talk about the essentials of tort of nuisance. Okay? Right. So there are four essentials basically. First of all, it must be a private wrong and civil wrong. Second one is unlawful or unreasonable interference. Third, interference with use or enjoyment of land. Fourth is damage. Right? Civil wrong. Coming to civil wrong. To constitute civil wrong, private nuisance. Basically, it must be a civil wrong so that the aggrieved party can file a suit in a civil court for remedy or relief, seeking unliquidated damages. Number 2, unlawful or unreasonable interference. Now, the plaintiff must establish that there is substantial interference with his right to use and enjoyment of land or property. To constitute nuisance, the interference should be unreasonable. Now, what does it mean? As long as the interference is not unreasonable, no action can be sought. If the interference is unreasonable, it is no defense. If the interference is unreasonable, it is no defense to say that it was for public good. Right? Now, we have couple of case laws here. The all famous Hollywood Silver Fox firm versus Emmett. Now, the first one is the all famous Hollywood Silver Fox firm versus Emmett. Now, what happened in this case? The plaintiff set up a firm for breeding foxes. Who is the plaintiff here? Hollywood Silver Fox Farm Limited, and erected a signboard saying Hollywood Silver Fox Farm. His neighbor, the defendant, who is Emmett, wanted to develop a housing estate on the land and thought that this particular board will deter his customers, and hence he requested the plaintiff to remove the board. The plaintiff did not agree to do so. The defendant warned the plaintiff that he would shoot along the boundary if the board is not removed. The defendant did accordingly. It caused damage to the plaintiff's animals, which are extremely nervous and do not breed in loud noise and may kill the young ones. In an action against the defendant, the plaintiff was entitled to get injunction and damages on the ground that no person can create noise on his own land, causing an annoyance to others. Second one, Radhesham versus Guru Prasad. Guru Prasad and another filed a suit against Radhesham and another for a permanent injunction to restrain them from installing and running a flour mill in the premises. It was alleged that the said mill would cause nuisance to the plaintiffs who were occupying the first floor portion of the same premises, inasmuch as the plaintiffs would lose their health, would also be adversely affected. It was held that substantial addition to the noise in a noisy location, the running of impunged machines, seriously interfered with the physical comfort of the plaintiffs, and as such it amounted to nuisance, and the plaintiffs were entitled to injunction against the defendants. Interference with the use or enjoyment of land. In private nuisance, an interference may cause either injury or damages to property, injury to comfort or health. Injury to damages or property, injury to comfort or health of an occupier of land. Injury to property, an unauthorized interference resulting in injury to property or proprietary rights is actionable as a nuisance. The interference may be allowing a tree to overhang its branches or to grow roots in the plaintiff's soil, or where the defendant. Okay, now we have a case law here. St. Helens Smoking Company versus Tipping. St. Helens Smoking Company versus Tipping. The fume from the defendant factory damaged the plaintiff's tree and plants. The defendants were held liable because such damage was an injury to the property of the plaintiff, injury to comfort or health. The interference with a man's comfort must be a material interference with an ordinary and reasonable standard of comfort. It must be considered in the light of circumstances of time and place. It refers from time to time and place to place. Moreover, discomfort and inconvenience are determined not by taking the plaintiff into consideration, but on the basis of average man residing in that area. Damage. In an action for nuisance, the plaintiff has to prove some actual damage has occurred. In an action for nuisance, the plaintiff has to prove some actual damage has occurred. In the case of damage to property, any sensible injury will be sufficient to support an action. Nuisance of this class arises from manufacturing works, chains, etc. Now, one case law would be St. Helens Smelting Company and versus Tipping. The other one is Dr. Bhimraj Singh versus Babulal. In this case, the dust and fumes from the defendant's brick grinding machine caused inconvenience to his neighbor, the plaintiff, who is a doctor. In an action against the defendant, permanent injunction was granted. In Kuhiram Gopi versus Uday Chandra, the nalas in plaintiff's land, who is Kuhiram Gopi, through which water flowed into the defendant's tank across agile portions were natural channels. As the waters accumulated in the agile portion, the defendant, with a view to transfer the evil, as waters accumulated in the agile portion of the defendant, within the agile portion, the defendant, with a view to transfer the evil of any injury to his land, constructed a bund, thereby diverted the flow of water of channels in another direction. So he made it a artificial thing now. That obstructed the flow of water through these channels. See, they were natural channels. He constructed a bund and gave another direction. That obstructed the flow of water through these channels into the tanks. Through these channels into the tanks, and resulted in diversion of accumulated water in the plaintiff's plot. It was held that it was not at all open to the defendant to build such embankment. Now, let me repeat the four major subheadings, the four headings. One is, it must be a civil wrong, unlawful or unreasonable interference with the use or enjoyment of land. First one is civil wrong, unlawful or unreasonable interference with the use or enjoyment of land, and damage. What are the case laws? Hollywood Silver Fox Firm versus Emmett, Radhesham versus Gurprasad, St. Helens Smelting Company versus Emmett versus Tipping, Dr. Rambaj Singh versus Babulal, in Kuhiram Gop versus Uday Chandra. That's it. We'll be shortly back with the tort of negligence.